This presentation addresses some important aspects of banking litigation from the perspective of the banks. The first thing a bank needs to know is when there is no need for it to litigate. There are occasions, believe it or not, when a bank need not or should not sue to recover a non-performing loan. So for instance, where the collateral for the debt makes it unnecessary for it to do so. That is, where the bank is able to exercise its power of sale under a mortgage, for instance. The solution in those circumstances is to enforce the collateral.
The second instance is where a cost-benefit analysis rules it out. That is where the cost of suing outweighs the possible benefits of suing, even if the bank is to succeed. And that's usually because the judgment debtor has no assets against which the judgment in the bank's favor can be executed. Internal counsel may be best placed to do the cost-benefit analysis. And the solution in those instances is to negotiate with the debtor for payment or for another institution to take over the debt.
And the other instance, of course, is where the bank is likely to lose. External counsel can opine on the likelihood of success prior to commencing suit and ought to be asked to do so. The solution in that instance is settle prior to suit.
And a second broad consideration for banks is the need to avoid inconsistencies in collateral security documents. The immediate objective of a suing borrower is to prevent the bank from selling their assets pledged as security for a loan. In order to be able to apply to the court for an interim injunction, the borrower must first have instituted an action against the bank for damages or some other kind of remedy.
Hence, borrowers suing banks will make all kinds of claims in their quest for interlocutory injunctive relief. Common examples of such claims are, for instance, where the borrower comes along and shouts fraud. That is where he's accusing the bank, for example, of falsifying security documents. Also, a borrower may accuse the bank of breach of an alleged fiduciary duty, when oftentimes no such duty exists between the bank and the borrower.
Such claims are tenuous at best, and if it can be demonstrated at an early stage, for example on an examination of the loan documentation, that the claim does not stand up to scrutiny, they can be struck out prior to trial, thereby saving the bank considerable expense. It is therefore critical for the bank's loan and security documentation to be in order. The terms of the security documentation should not conflict with the terms of the loan set out in commitment letters. If the loan is not standard, the bank should not use standard term documentations, because one size does not fit all. A winnable case does not start with the claim form or the defense, as the case may be. It starts with the steps that are consciously taken or avoided by a bank when the loan is sought. Lawyers are not magicians.
For this reason, it's very important that when banks are sued or whether they are suing, they should have what we call their ducks in a row. What does that mean? As you know, banks are not litigious by nature, preferring whenever possible to conduct their business quietly. It is incumbent upon them, however, to conduct their business in such a way that their every action is explicable and defensible. A bank's actions should be fair and should accord with common sense and reason.
Sandra, can you explain what's the importance of maintaining bankers' books for the banks?
Sure. The reason why it is so important for banks to keep a record of their every interaction with their customer is so that they can adduce it in evidence without necessarily having the bank employee available. So for instance, the Evidence Act allows for bankers' books to be admitted in evidence as prima facie evidence of what the bank is trying to adduce. So it begs the question, what are bankers' books? Bankers' books include ledgers, day books, cash books, account books, and all books used in the ordinary course of banking.
The second thing that the bank needs to do to put itself in a good position if it is suing or being sued is to ensure that there are no unfair contract terms in its documentation. Although Jamaica does not have an Unfair Contract Terms Act, it has, since June 1, 2005, had a Consumer Protection Act in existence, which requires that contract terms are fair and reasonable, having regard to all the circumstances which were known by or in the contemplation of the parties when the contract was made. If called upon to do so, banks must establish that every contract term is fair and reasonable. When all these things are in place, as they should be, then the cost of litigation is substantially reduced because the bank is invariably able at an early stage in the litigation to strike out its opponent's case or to go for summary judgment on its claim or on the defense so as to avoid trial costs.
So to conclude, proper attention given in due time to each of the matters of importance to banking litigation can contribute immeasurably to the bank's objective of winning the cases brought against them quietly in the most cost-efficient way.